Right, welcome back, everybody. Lots of stories to get through this morning. We'll return to that taxi strike in a short while, and we'll bring you updates from around this area in our news bulletins as well. But now let's turn our attention to the High Court in Pretoria, which recently ruled that taxpayers have a right to be notified before SARS appoints an agent to collect outstanding tax debt. Section 179 of the Tax Administration Act allows the SARS Commissioner to appoint a third party to hold money on behalf of a taxpayer and to pay such monies over to SARS in respect of outstanding tax debt. This third party is often a bank. Now, we did invite SARS to the conversation, but they said they are studying the judgment currently. But joining us now, we've got Althea Soobyah, who is the Director of Tax Consulting at Mazars. Good to have you, Althea. Thanks very much for being with us this morning.
Thanks, Leanne. Thanks for having me on your show.
It's a pleasure. So, in essence, before this judgment, SARS could appoint whoever they wanted to collect outstanding debt. Now, with this High Court ruling, they must notify the taxpayer. Perhaps you can explain a little bit more to us for those that don't understand exactly what this means.
Sure. So if we just take a little step back, before 2015, SARS could appoint a third party to collect debt without any notification to the taxpayer, any outstanding debt that was due to SARS. Post 2015, however, there was an amendment to the legislation introducing Section 179, subsection 5 of the Tax Administration Act to the legislation, which ultimately reinforced the administrative justice principles, which indicates that if any administrative body wants to take a decision that adversely affects the rights of a taxpayer, they need to notify the taxpayer of such decision before actually taking or appointing a third party in this matter. So what this case really dealt with, and of course there is an exception to the rule where SARS has the right to appoint a third party without notification, but that's an exception. In this particular case, the High Court dealt with a matter where notification was a requirement in terms of the legislation. SARS, however, prematurely issued what they deemed to be a notice for the outstanding debt prior to the expiry of the due date for payment. Further than that, a notice that was generated by the SARS system was never posted onto the taxpayer's e-filing profile. Now, that meant that this was then defective. And the High Court ruled, one, that the notice was defective, and two, that the notice issued prematurely was an invalid notice. So basically what the court has now reinforced is the principle of fair administrative justice and the right to be notified before SARS actually appoints a third party to collect an outstanding debt.
Okay, so prior to this, let's get an understanding of how SARS actually used third-party collectors and what issues occurred when they did this to people that they were targeting.
So usually what happens is SARS would raise an assessment and there would be a due date on the assessment for payment of the outstanding debt. What SARS did in this instance is they issued a reminder to the taxpayer prior to the expiry of their due date on the assessment. After expiry of the due and the assessment was under dispute, but there was no suspension of payment granted. And based on the pay now, argue later rule, the debt is not automatically suspended by a dispute. Okay. There needs to be an application for that to occur.
Yeah.
So in this instance, particularly, there was no suspension of payment, so the debt would become due at the end of November. However, SARS issued the notification prior to the due date, expiry of the due date, which meant that the debt hadn't really become due at that particular point in time. But SARS then further to that, after the expiry of the due date, issued what they call a system-generated notice, a letter of demand in other words, but was never sent to the taxpayer. So the notification requirement was never met.
Okay.
And SARS relied on a premature notice as well as the defective or non-delivered notice as their notification to the taxpayer. for the third-party appointment. Now, we've seen SARS use third parties to collect on debt that is outstanding, and it is well within their right to do so. But they also have an obligation in these instances to follow the letter of the law and to follow proper process, which they didn't do in this particular case.
All right. Okay. So,
and yeah.
I gather we're running into time, but I think I think you've outlined it quite well in terms of how it worked, what they would do and rely on, and also there I believe are 6 criteria that SARS must actually use before a third-party collector, and you've outlined a couple of them, not all of them. Unfortunately, we don't have the time, but when we look at the cost, who actually bears the cost of all of this? Is it something the third party? Is it a thing that the taxpayer will then have to use the money and pay for this to happen?
Sorry, Leanne, you broke up a bit, but I'm gathering.
Talking to the cost, just to talk to the cost, if SARS is using a third party, does it involve a cost to the taxpayer who actually owes the money?
Well, inadvertently it does, because the taxpayer, if SARS had not followed process, would have to apply to the High Court, similarly in this case, for that money to be repaid. And we all know that the cost of litigation is expensive for taxpayers, normal taxpayers trying to carry on their business, especially in the current climate. So it would cost the taxpayer to have to bring an application to the High Court, appoint counsel to bring that application, and if it is an urgent application that needs to be brought to court, then the costs are even greater for the taxpayer. So usually the costs are borne by the taxpayer. Yeah. In this particular case, however, interesting to note is the court gave an order for costs against SARS for not following due process.
Okay. So let's wrap this up, Althea. So this is a victory for the taxpayer, no doubt, so that this in future doesn't happen. However, SARS still have the prerogative, after studying the particular outcome of this case, to take this further. Are you expecting them to do something like that?
The SARS has the right, like you said, to take it further on appeal. However, given the merits and the facts, the Supreme Court of Appeal won't necessarily look at the facts from the beginning, so they will look at whether the High Court had actually erred in their ruling. And in my view, I don't think it's one that SARS would want to take to an appeal.
Althea, we leave it there. Thanks so much for chatting to us. Althea Soobyah, Tax Consulting Director at Mazars, talking to us about this recent High Court ruling that taxpayers have a right to be notified before SARS appoints an agent to collect outstanding tax debt. And usually that agent is the bank that they bank with, the taxpayer's bank. So this, of course, is something that we'll watch and see what further action SARS take with regard to this case. All right, just after 7:30, let's get your news headlines.